Day 2 of the Supreme Court hearings on President Obama's health care reform law, a day that focused on the most contentious part of this plan, and that's the individual mandate. That's the provision requiring Americans to buy health insurance by 2014 or to pay a fine. And Andrew, this not so much a good day for those who want to keep this law in the books.
And that may be a bit of an understatement, Rich. The justices today focused in on that constitutional authority that allows Congress to make that requirement, and the justices may be split on both party and ideological lines. Critics, the conservative Republicans, not finding that constitutional authority. Supporters, the Democratic and progressive justices, embraced it. 3 conservative justices could be the key to how the Supreme Court rules on the president's health care law. And today they expressed deep skepticism about the insurance mandate. Justice Antonin Scalia saw a slippery slope in the requirement that all Americans buy health insurance or pay a penalty.
If the government can do this, what else can it not do?
Chief Justice John Roberts seemed to agree.
Can the government require you to buy a cell phone because that would facilitate responding when you need emergency services?
And Justice Anthony Kennedy, seen as the key swing vote, pushed back strongly against the Obama administration's case.
Can you identify for us some limits on the Commerce Clause?
The tough questioning by these 3 justices may indicate trouble for the president's signature domestic achievement. Lawyers for the Obama administration argued that the mandate is the only way to finance something that everybody needs at some point in their lives.
People cannot generally control when they enter that market or what they need when they enter that market.
But attorneys for the 26 states that filed suit argued that Congress can't force an individual to buy something.
The mandate represents an unprecedented effort by Congress to compel individuals to enter commerce in order to better regulate commerce.
As for the reactions from court observers, pretty much overwhelming. It was a bad day for the health care law and the people who wrote it. The New Yorker's Jeffrey Toobin writing, "It was a train wreck for the Obama administration," adding, "I think this law is in grave, grave trouble." Nonpartisan court watchers at SCOTUS blog writing, Paul Clement, he's the lawyer for the states, gave the best argument I've ever heard. No real hard questions from the right. Mandate is in trouble. Finally, NPR's court reporter Nina Totenberg, conservative justices to Solicitor General Donald Verrilli, they beat him up pretty hard, she wrote, but adding, "I don't think you can call this." That might have been the most optimistic view of keeping the health care law from the court watchers that I saw today. And the Solicitor General apparently really had a bad day today. Started off stumbled in his remarks, cleared us through, like bad performance. We'll see if that harms the argument that he was making. Rich.
No pressure there, being talking to the high court here and the world watching with a lot at stake. If I can, I want to give the pros and the compelling arguments for both sides of this, and obviously this is a surface statement, but these the 3, 4, and against here. Now these are the arguments for. This is the only way to afford full coverage in America, and even then, not everybody's completely covered in this. Also, this would help the insurance companies here that otherwise would be unsustainable, and the uninsured will cheat the system without a mandate. If you don't have everybody buy in, you can't have it. Then, on the con side, that this is government overreach. The Commerce Clause does not empower the government to do what they did. You can't force people to buy something that they don't want to, and there is no precedent in law, they argue, or for that matter, court, to do something as wide-ranging as this. All right, let me do reverse order here, Andrew. You heard the court. You heard what happened today. The Commerce Clause, do you believe that it is an overreach and that this is without precedent to try and do something like this, to have universal health care or something approaching it with Obamacare?
The problem on this is that it's forcing Americans to pay to private companies. If we were talking about government health insurance, I don't think that would be an overreach at all. I think it's a bit of a strain on the Commerce Clause at this point. However, the greater good may actually outweigh that. And so the justices, while they may not be enthralled with the use of the Commerce Clause here, may be willing to bend it or look past it because of the overall significance, the overall importance of health care reform.
And also some of the consequences if they did strike it down. There's consequences on both sides.
That's what they get to tomorrow. What happens if we strike this down in part or in full? And if they just...
And not just to health care, but overall. Then there's going to be broader questions about other pieces of just reality in today's American life that could go by the wayside. Dominic, what do you think?
I think I agree with the
You can just call me Andrew.
with the public broadcasting analysis that you did.
Yeah.
I was about to get sick if you were going to say my esteemed colleague or something, but anyway, yeah.
We can read tea leaves all we want to with the Supreme Court. It may have been a bad day for the mandate issue, but you really don't know with this court. And what's overriding almost over their shoulders are how they're viewed by Americans in terms of the bipartisan issue. So I really don't know. I really don't
You know
know.
what? I used to think that mattered a lot. I'm not so sure they care anymore.
That's a good point.
And now, Congressman, if given an opportunity, you would have voted against this piece
I
of
would have
legislation.
voted against it for several different reasons. And by the way, I did vote for prescription drug Part D, which, working with Nancy Johnson, moderate Republicans, moderate Democrats, and others, it took us 4 to 6 months. But we worked out all the details. We got it through. The hard left and the hard right didn't like it, but that bill has been sustained. It's come in under cost, and it's got an 85% popularity with seniors. This bill was rammed and jammed. Nancy Pelosi didn't even know what was in it. Harry Reid is shelling out $300 million, $600 million to get the Senate votes, and it's a disaster.
We
It
can debate the
overreaches.
process of it, because I never think there would have been a pretty baby that would have come out of this thing the way Congress was. But let me ask you, what happens? Why can't we make the argument, can't drive a car without auto insurance? Social Security. It's not one of those things where you really have an option if you want to participate in it or not. There are things in this country that by being American citizens, you have to be party to. I don't know people who say you may want to privatize Social Security, but the way it is right now, all four of us pay into the thing.
Healthcare is managed by the states. The reason Romneycare is not before the Supreme Court is because the states for 200 years have managed and licensed doctors, nurses, hospitals, and the provision of healthcare. The federal government provides funds for Medicare and Medicaid that's managed by the state. This is a federal mandate that reaches across all of those state lines, which makes it comparable example. No, it's not comparable at all. Social Security is an insurance program. It's a tax. It's a FICA tax, and you pay a Medicare tax. So you are taxed into a program from which you eventually get a benefit. This is an overreach, and you're being mandated to buy a product that is not traded across state lines, and that you don't
want.
want.
Other than that states' right argument, there's no specific functional argument against doing it. If the only argument is that, well, this is decided for the states, I'm sorry, but I throw that out the window, because if it's in the best interest of people, that supersedes, to my mind, states' rights on something like this.
I
think that the people, what this says is that those issues that aren't specifically provided to the federal government under Article 1, Section 8, resolved to the states. There's nothing in Article 1, Section 8 that goes to health care.
The court tomorrow is going to say, though, wait a second, if Rich French doesn't have health insurance and I get sick, I'm going to the ER.
Yes, you are.
And you three guys are paying to take care of me.
That's correct.
So in the end, the American public, unorganized or organized, is going to end up having to pay for my health care. Why doesn't the government, if we're already paying for it, doesn't have,
Because under the current system, your state-based hospitals will pay for your health care if you go into the ER. Health care has traditionally been state-based. Again, that's why Romneycare was never brought up in front of the Supreme Court.
They're going to get their money from Medicare. They're going to get their money from Washington to offset some of those costs. It's going to wind up being a federal issue anyway. It's just a semantical argument that this is a states thing. As opposed to a
Semantics
federal.
are not here. It was not a good day, certainly, by all accounts here, for those who would like to keep it. And we did see, by the way, a sighting of Rob Simmons's Constitution. So yes, all is right in the world. There it comes.